Good evening, students. In today's session, we will be starting with the Hindu Adoption and Maintenance Act. The Hindu Adoption and Maintenance Act are the laws that relating to adoption and maintenance, which generally depends on the personal laws of different religion. Specifically in India, the Hindu Adoption and Maintenance Act 1956 governs such other laws for Hindus, Jains, Sikhs and Buddhists. It basically contains provisions relating to the adoptions of children, maintenance of wives, children or the aged parents, etc. The Hindu Adoption and Maintenance Act is one of the most prima facie important personal laws of India. This is because it affects a large number of people. The act also applies to Hindus following any kind of caste, sect, which might include the Vaishnavas, Lingayats, Arya Samaj, etc. The Hindu Adoption and Maintenance was enacted in 1956 as a part of the Hindu Coded Bills. The other legislation that enacted during that same time frame were the Hindu Marriage Act, Hindu Succession Act, and Hindu Minority and Guardianship Act. The Act contains several comprehensive provisions, especially the laws relating to the adoptions of children by Hindus. And in fact, Section 5 specifically talks about any adoption in contravention of the Act is considered to be void and has no legal effect. In this particular session of today, we will be dealing in two sections. On the first part, we will be dealing with the adoption, and in the second, we will be talking about the maintenance. The Hindu Adoption and Maintenance Act, as I have told you, not only covering the Hindu, Buddhist, Jains or Sikhs, but it also covers the couples, single adults, and also has given the capacity to for a man to adopt with the consent of his wife. Even if a biological child already exists in the family, a child of opposite sex has to be adopted. So these are the certain kind of categorizations, if you can see in this slide, which is talking about the various process of what are the conjuncity on which this entire act deals on. In the sixth slide, if you kindly see, it also enunciates the legal rights of a biological child, children under the several n number of features, ingredients. If I talk about like what type of children can be adopted, so which also mean that under the age of 15 years has to be adopted. So beyond the age of 15 years cannot be adopted. And I have dealt in previous classes also, in previous sessions. I have also talked about why is the reason that section age of 15, below the age of 15 is considered to be a minor and not beyond 15 years. In this particular act, you will also find out that even a single woman can even adopt a boy, but must be comprised of 21 years of differences. Before we actually jump onto the entire details of the Hindu adoption, it is very essential to look around what other set of acts or adoption laws that we have in India. The first, of course, as I've told you, is the Guardians and Wards Act 1819. Before any kind of juvenile justice that came into existence, this was the only legislation that allowed non-Hindus to get adopted. However, in this particular act ended up in the first secular law that allowed the children to get adopted, and the adopted parents was considered to be a guardian and the child was considered to be his ward, which is almost same as that of the biological child having relationship with his parents, and also of course in relation to the inheritance is concerned. But the other whatever features comes in the Guardians Act are almost same in the which is very common in the other laws which will be coming across. That is the 18 years can be revoked, the guardian can be revoked by the court, even a will if required for any property goods to be bequeathed to the child. Both the spouses, if they have adopted, will be legally the guardian, and of course the single person can also adopt with any age difference restrictions. Uh, so you one need to understand in this guardianship and what's act, even though it was implemented in or have a retrospective effect, yet it do give an introduction, a glance to the future adopted laws or future adoption and maintenance laws of children, and of course of the women concerned. The second set of act, if we talk about, is a very common one, that is Juvenile Justice Care and Protection 2000, amended in 2006, wherein again the adoption has been given a major stress in this part. Uh, uh, However, there are certain kind of conditions which has also been withdrawn in this particular category. That is the any adoption related, any Indian citizens to can adopt a child who is legally free to for adoption. Now, who is legally free for adoption? One need to understand that if a child is already being adopted or in the process of adoption, such child cannot be claimed for the another mode of adoption. The second important is that the religion of the adopted parents is not relevant here. In Hindus adoption maintenance, we will be seeing that there's a major contradiction on religion methodology, that only the Hindu parents has to have adopt a Hindu child only, which is a bit kind cliche in today's generation if we talk about, but it still existed. But however, in juvenile justice, such cliche laws are not there. So basically, religion of any parents can adopt any child, because at the end of the day, it's a very common notion that a child has no religion, of course. The next important features, if you kindly see, single parents adoption, and of course certain limitations have been ensured that children can be given free, legally free for adoption earlier, but the thrust of the whatever the process goes on this particular, under this particular, is basically based on the court to decide, and of course onto the welfare of the child is concerned. The next important features that you need to see is the juvenile defines adoption in section 2AA. Earlier, if you kindly see, it was never been concern, it never been was a major concern for adoption, but with later amendments we do see that section 2AA, a separate clauses has been given, has been recognized for the privilege to be given for the adoption and under this particular act, and also to for any parents who can with adopting remain like a or can procreate its normal parenthood. uh, Article 44 also do talks about that state also to endeavour a uniform civil code through the territory of India. And on this particular agenda also, the main important things also congregates maybe from for this, that the in this particular act is one of the shadow of that particular article, which gives which is a common platform, which in which the parents are given a common platform for adoption without seeing its religion, without seeing its caste or creed or anything. Further, in this particular section, there are one more important, that is section 41 of JJ Act, which to be read with Rule 33 Clause 1 of Central Rules, which is the following aspect of the adoption, in which it says that the primary aim of the adoption is to provide child who can't be cared or by his biological parents with a permanent substitute family. The family of the child has the primary responsibility to provide him care and protection. Orphan, abandoned, or even surrendered children can be adopted for their rehabilitation through such mechanisms which is prescribed under JJ Act. Further, also, Section 29 of the Juvenile Justice Act 2000 provides for the Child Welfare Scheme or Child Welfare Committee, in which the sole authority while processing with the adoption is to declare the child in care and protection to be need to see that they are orphan, abandoned, and are free for legal adoption. The next important which is very important for your syllabus, which is international adoption, or we can say inter-country and intra-country adoption. Now, what is international adoption? International adoption are nothing but the modes through which Indian citizens or NRIs or non-Indians residing in India can adopt a child from India. While this adoption is a new procreation of this act, of this adoption laws, yet this has been legalized, and the rules related to this adoptions are totally different. These differences are a functioning of the priority given to the Indians which are residing in India while placing a child, the regulations of the country in which the adopted families reside, and the relevant immigration laws are also needed to be seen. In India, specifically, if we talk about the international adoption section, the adoption of Indian child by a foreign citizens is covered also by the guidelines, that is Adoption of Children 2015. And this guidelines has been enunciation to stop any kind of illegal or misusal of children via adoption. As per the Supreme Court guidelines, foreigner also can adopt an Indian child before the age of 3 years, and in the absence of any concrete act of inter-country adoption, the provision of Guardians and Wards Act are being followed while giving in adoption under this particular categories. The next important, if we talk about here, also one more you need to understand, this particular inter-country adoption also does not talk about the ceremony of Datta Homam, which is which is the way of accepting the adoption through certain kind of rituals. Such old laws are not even being contradicted here. Yet it also depends upon the parents. If they really want to, it's up to them. But so for all, such kind of rituals or enunciating rights has not been mentioned in this particular legislation. The next which we will be starting on is with the adoption in a conceptualized manner. Adoption in simple terms, if we talk about, as I've said, that means of accepting a child of other parents as your own. So this is a simple plain English if I want to define adoption. And in fact, in the case of Inder Singh versus Kartar Singh, the court stated two main objectives on the purpose of adoption. The first one is to secure the child of a person's funeral rights, and also to preserve the continuancy of one's blood lineage. Further, if one need to understand the in this particular act also, there are certain kind of requirements being given, as we have studied in section 5, the valid requirements of marriage. Similarly, in adoption also, we have been given certain kind of ingredients as a valid adoption, and they are that no adoption will be valid if the person is lawfully capable of taking, is not lawfully capable of taking in adoption, or lawfully capable to give adoption, nor person adopted is lawfully capable of taking adoption. The adoption is completed by an act, and here the Datta Homam is being prescribed. That is, after you take in adoption, this particular ritual has to be performed in front of the fire so as to seal it with confidence. The next is that along with that, there are certain other forms of conditions being given, that if the adoption is of a son, the adopted father or the mother by whom the adoption is given must not have a Hindu son. Similar also in the case of the daughter. And if the adoption is by a male, then he has to have a 21 years of age difference, and he has to adopt an opposite gender. Similarly, if it is for a woman, the same will be followed. It's opposite gender and the major age gap of 21 years. Now, in the types, if we talk about, there are certain kinds and types of adoption. The first is open adoption. That is where the adopted parents and the birth parents keep in touch with each other. Semi-open, where it doesn't, no direct contact between the birth and the adopted parents are there. Closed adoption, this kind of adoption usually involves that no contact, absolutely no contact with the adopted and the birth parents. Intra-family adoption is that where the adoption happens within the family relation. Domestic, where it is being adopted within the territory, within our country. Inter-country or international adoption, where the Indian child is being adopted by parents having who are outside the country, or who is an NRI specifically. Who can be adopted? Any person can be adopted, but in this particular act, if you kindly see the slide, any male, specifically a male who is, again, the religion is mentioned, that is the Buddhist, Jain or Sikh, has to adopt and is eligible to adopt a son or daughter. Similar, he must not have but if such a male have a living spouse at the time of adoption, then the adoption has to be validated after taking due permission from the or due consent of the wife. Similarly, if any female, again the same process applies. Has to be particular this category, that is like either Hindu or Buddhist, Jain or Sikh. And if he's not married, or if married, whoever whatsoever, if the husband is not alive or her marriage has been dissolved, has been declared incompetent by the court, has the capacity to take a son or daughter. So here again, a special privilege is being given to the female, even if you're married, not married, divorced, the woman has the capacity to take in adoption. The next, which is very much important, is that who can be adopted. Matlab, what are the child that can be adopted? The child can be either male or the female. Should fall under specifically under Hindu category, and also should not be married under any circumference, or a child marriage should not be have done. Should be below the age of 18 years. And of course, should occur, the adoption can only occur if there is not a child of the same sex. So, if the parents already have a biological children, the same sex children cannot be adopted. So, for example, if the parents have already a biological son, then they cannot adopt a adopted son, but rather of opposite gender can be adopted. Similarly, for the prospective parents, they have to first register, and only after the agency finds their suitability, the processing of the adoption takes place. Now, section 7 is one of the most foremost important of all the section, because it talks about the male to take adoption, or the eligibility of the male for adoption. Once you will be going through, you will find a very similar instance with that of the Hindu Marriage Act, where especially with section 5 and 7 and 8, and of course with the 11 and 12. Here again we will be seeing that a Hindu who is not of unsound mind, or who is not a minor, or he shall not adopt without the consent of the wife. If the person has more than one wife, then of course all the consent of the wives is very much necessary to be taken. And in this particular case also, and of course, the consent of the wife of a male Hindu is not necessary in the following three conditions. If the, a certain kind of relaxations being given to the Hindu male, wherein the husband need not required to take permission from the wife if he has renounced the world, or has ceased to be Hindu, or has declared by the court as a competent, as unsound mind. In this particular scenario, Krishna Chandra Sahu versus Pradeep Das named case, which is one of the very most important case, wherein the court opined, the Orissa court opined that where the above three disabilities have been propounded by from the court and have not been established, the consent of such wife uh, would be mandatory, then in such situation the wife is very much allowed for the valid adoption. But if the consent of the wife is not established, the court will be declaring that adoption to be null and void. The next is section 8, wherein the adoption of a female becomes another, wherein whether what are the capacitiate or eligible criteria required for the female to take in adoption. Similar, that is of the, she has to be a sound mind, not a minor, not married, and if married, whose marriage has been dissolved, or whose husband is dead or completely has renounced the world, or has declared by the court as an unsound mind, has the capacity to take a son or daughter in adoption. Again, where the woman is married, it is a son, it is a husband who has the right to take in adoption with the consent of the wife here. Now, again, in section 9, you will be seeing the person who is giving for adoption, that is a biological parents, has the capacity or rights to give in adoption under following condition. Now, the adoption has to happen only by the father or the guardian, or the mother or the guardian. The mother, the father, if he is alive, then he has the entire right to exercise the process of adoption with the consent of of course, with the mother. And unless the mother has completely renounced the world, in such situation, the father need not require to take in to give in adoption. Similarly, the mother also has the same situation if the father is dead, or he's renounced the world, or has competent husband has been declared to be an unsound mind. In such situation also, the woman herself also can take in adoption. And in case where both the parents are dead, in such situation, the guardian of the child may give the child for adoption after the due diligently taking permission of the court. And after the court gets satisfied from the guardian's process of adoption and understanding the child, uh, depending on the situation, payment or reward in consideration for the adoption may be decided, but it depends upon the discretion of the court. The next important is again the section 10, which talks about the person can be adopted. It is in section 10, somewhere down the line, you might have a different type of question, because here you'll be seeing that a certain kind of points may be questioned, or you may ask question. But here again, you need to understand the situations and provocations on which this entire act was being contained. Of course, the adoption laws, as per the rules of the society, may look a bit deteriorated, may look a bit kind of old incident situation or section, especially when we'll be studying section 10. But if one act is a bit retrospective, but we have the other acts which do comes in rescue, thereby maintaining the prodigy of the adoption. In section 10, if you kindly see, no person can be adopted if he or she is a Hindu. No person can be adopted unless he is a Hindu, or has not been adopted, not married. He or she has not completed the age of 15. So, under such situations only, the section 10 can be considered. The next important is the adoption of an orphan. In this situation, one of the important judgment, that is the Balakrishna versus Survive and Mayaram versus Jay Narayan. Here it was being held where the customs or traditions allow there are person above 15 years of age or married who can be adopted. So provided if the custom is permitting, then beyond the age of 15 can also be adopted. Here in this particular chapter, in this particular section area, you will see that in the present law also has taken concern over the orphans who can be taken in for adoption. In such cases, the guardians of the orphans can obtain permission from the court for giving in the child for adoption. In Devgonda versus Sham Gonand, Bombay High Court held that any insane can also be adopted for and even an abandoned child can also be adopted. So in this situation, one can see that adoption, even though certain laws are very old in nature, but here again this laws makes the entire Hindu Adoption Maintenance Act way more relevant and much more dynamic in nature. In this slide, you'll be seeing the section 11, whatever which talks about the residuary conditions. Those are required as a valid adoption, wherein it talks about that, which comes in section 11, of course, that if the adoption is of a son, the adopted father or the mother whom the adoption is made must not have a Hindu son or any generation of son. Similarly, if it is of daughter, then neither the legitimate bloodline should not comprise of his daughter, or the should not have any kind of grandchildren of female category. And if the adoption is by a male and the person is to be adopted as a female, the adopted father has to have a 21 years of age gap. Similar with the female also. But the same child cannot be adopted simultaneously for 2 times. And once a child is adopted, must be actually given and taken in adoption or under the authority with intent or transfer of the child. In such situation also, where it is being brought up, he has to, with the intent to transfer the child from the family of its birth, or in the case of an abandoned child or child whose parentage is not known, from the place or family where it has been brought up to the family of its adoption, provided that the performance of again this Datta Humam is not required under this category. Section 12 again talks about the effect of adoption. Now, this is one of the most important section if you talk about in relation to your exam purpose. Effect of adoption is one of the most relevant. Why? Because it talks about that post effect of a valid adoption. What are the things which are required to be maintained or need to be remembered? The first one is that an adopted child shall be deemed to the child of his or adopted father from the day when he is being taken in adoption, provided the child cannot marry with whom he or she could not have married if he or she had continued in the family. So basically, wherein in the birthplace of the child, if some person has been decided for marriage, such child cannot marry such kind of person. Similarly, in the case of property vested, which vested in the adopted child before the adoption, shall continue to be rolled on, subject to certain kind of obligation, if any, attaching to the ownership of the property, which includes the obligation to maintain relatives in the family of his or her birth, and the adopted child shall not divest any person of any estate which was vested to him or her before the adoption. So basically, whatever being received, it can continue but cannot be vested or cannot be distributed to his present family's generation. Section 13 talk about the right to adopted parents to dispose of their property. Where there is no agreement of the contrary, the adoption does not deprive the adopted father or mother of the power to dispose of his or her property by transfer, inter vivos, or by will. Therefore, the adopted parents is in no way to restrain in the disposal of their property by reasons of adoption. Adopted parents actually have the right to dispose of his property, that is subject to an agreement to the contrary that might have been entered into the time of adoption between the adopted parents and natural parents. Therefore, under this particular act, agreement restricting the power of alienation of the adopted parents is totally void. The next is section 14, which talks about the relationship of adopted child. The adopted child in this particular section is again one of the important one, because it talks about that the relationship of adopted child and the natural bond should not be differentiated. Where a Hindu who has a wife living adopts a child, he shall be deemed to be the adopted mother, and if a father adopts, he will be considered to be the adopted mother, provided if this adopted father and adopted mother remarries in future, they will be comprised of having a stepmother or stepfather, vice versa. Where a widow or an unmarried adopts a child, any husband whom the widow or the unmarried married subsequently turns out to be the adopted father. The next important section which is need to be important, the next part which we will be studying is the maintenance of wife, that is section 18. What does a maintenance means? If one needs to understand, maintenance duly means giving food, shelter and clothing. So therefore, when we talk about the maintenance, when we talk about the concept of maintenance, it becomes a very important thing, because at the end of the day, uh, this particular section, this particular chapter gives a way to prevalent to the maintenance of wife, to the children, and of course to the widow, and to his widow daughter-in-law, even for the separate residence. So in section 18, it talks about that the Hindu Adoption and Maintenance Act deals with the maintenance and separate residence of a wife. Hindu wife, whether married before or is living separately from her husband, without forfeiting her claims to maintenance. It is in this particular section, you need to understand that a Hindu wife shall not be entitled to separate residence and maintenance from her husband if she is unchaste or cease to be a Hindu by conversion to any other religion. And if he keeps a concubine in the same house in which his wife is living or habitually resides with a concubine elsewhere, a Hindu wife shall not be seized. If he's one important thing is, in this particular case, the Purushottam Makad versus Srimati Annapurna Makad, Supreme Court opined that the right to claim maintenance, especially the interim maintenance in a suit, is a substantive right under section 18, and since no form is prescribed to the enforce the said right, civil court in exercise of its inherent power can grant the interim maintenance. Here again in section 19, we talk about the right of a Hindu widow to claim maintenance from a father-in-law. So basically, it talks about section 19, that a widow daughter-in-law is entitled to be maintained by a father-in-law under following conditions. The first is that a Hindu wife, whether married before or whether married after the commencement of this act, shall be entitled to be maintained once the death of his husband happens, provided to the extent that she is unable to maintain herself. And in this situation, in Raj Kishore Mishra versus Meena Mishra, it was held that where from estate of the parent, the daughter-in-law can maintain herself, questions of father-in-law does not arise. Similarly, so like the previous section, this section 2 must be read with section 23, because it lays down the discretion of the court to decide whether any of it, or if so, what maintenance shall be awarded under the provision of this act. The next is maintenance of children and aged parents. Here again, under this section, that is section 20, the act does not merely the father, but mother is also being categorized as the under a legal obligation to maintain the son or even the illegitimate child. In this particular section, please understand the parents also includes a childless stepmother also. The next is here section 21, which defines the word dependent. Now, according to the dependent, and why you might understand, why you might have question why we are studying the definition of dependent, because dependent can be anyone, and based on this definition, the distribution of the property or any kind of inheritance forfeitures are usually depends upon this definition only. So imagine if the father is dying, and whoever comes under his dependence, or whoever comes under his dependence, they are all comes under the getting benefits from the nomenclature properties or any kind of inheritance of the father, or rather they become the co-partners to that aggrieved co-partner to the deceased property. So here again, for in the dependents has been categorized as one of those, that is the father or her mother, or his or her mother, even the widow, and even the widow, even the predeceased son, or his predecessor son, so long as the same is minor, provided that you need to understand that he is unable to obtain maintenance in case of a grandson from his father or mother estate, and in the case of a great grandson from the estate of his father or mother, or the father's father or father's mother, that is from grandfather or from the grandmother, or if there is having an unmarried daughter, or the unmarried daughter of the predecessor son, or the unmarried daughter of a predecessor sons of his son, so long as she remained unmarried. Further also provided that, and to the extent that if she is unable to obtain maintenance in the case of a granddaughter from a father's side or mother's side, and in case of a great granddaughter from the father or from the grandfather's side or from grandmother's side, in such situation his widowed daughter shall be acclaimed, provided and to the extent that she is unable to obtain maintenance from the estate of her husband, or from her son or daughter's estate, or from her father-in-law's estate, any widow of his son or a son of his predecessor son, as long as she is not married. Last but not least, of course, the second is the amount of maintenance. So that is one of the most important. Here again you will be saying that while determining the maintenance, it always depend upon the court to determine, based on the situation, that on what category will the maintenance be given. In determining maintenance of widowed maintenance of the dependents, as I've studied, or maintenance of widowed, we have seen the category on which each categories can be considered to be a dependent. Now, based on that dependency only, this amount of maintenance, that is section 23, is decided. Section 23 of the Act provides that the amount which a person is entitled to, that is, number one, it shall be the discretion of the court to determine, and the amount payable by of maintenance depends on the fact of each case, and no exceptions could taken to the amount fixed by the trial court. And if a dependent's claim for maintenance under this Act shall not be charged or charged, or can be claimed, the amount maintenance, whether fixed by a decree of a court or by agreement, either before or after the enforcement of the Act, may be altered subsequently if there is a material change in the circumstances justifying such kind of alterations. The next is maintenance of wife. Now, maintenance of wife, even though it's mentioned in section 25, there are section 125 CRPC also, which also talks about the maintenance of the of a divorcee, and of course a widow also. So when you're writing section 25, you have to club it out with section 125 CRPC as well. Here again, one need to understand that there are almost a number of sections. There are three categories in which the section 25 has been divided. There has been in these three situations, you need to understand that in each category, this particular thought process or the particular maintenance has to be prevalent. For example, if I talk about the first section, it's subject to the provision of this section, Hindu wife, whether married before or after, shall be entitled to maintenance. And if wanted, he can also entitled to live separately from her husband without claiming any kind of maintenance. And if he is guilty of desertion or abandoning without the consent, or if he has treated her with cruelty, or if he is suffering from virulent disease, or have a bigamous relationship, or living with a concubines, or have been converted, or is living separately, in such situation, he is entitled to get not only a separate to live separately, can get clemency to live separately. Furthermore, also in the last, if you say section, a Hindu wife will not be entitled to get a separate residence or maintenance if she is a impure or unchaste or has converts to another religion. So that was all from Hindu Adoption and Maintenance Act. In through this slide, if you find anywhere any difficulties, even though proper study materials as per to the slides has been shared, again, if you're having any kind of confusion, any kind of doubts, please feel free to contact via mail ID. I hope everyone knows. Thank you and all the best.